Mm. Mm. Well, thanks for staying with us. We have with us now Daniel Bwala, who is a legal practitioner and also a member, Linkers in London. You're welcome to Sunrise Daily.
Thank you. My pleasure, always.
Well, you've listened to a professor's perspective.
Right.
He believes that we should question the commitment of the Attorney General of the Federation. Do you agree with him?
No, I don't. What has happened, in my opinion, is a clear failure on the part of the players, in this anti-corruption fight, beginning with the advisory committee. So what they are doing now is, in my opinion, a blame game. Because if you recall, every act of government, the first person that goes to the media to defend it is the chairman, has always been the chairman of the Anti-Corruption Advisory Committee, and not even the Attorney General. To the point, people even assume that their position superimposed that of the Attorney General. When the judges' homes were raided, the chairman of the Presidential Advisory Committee was the first to defend it. And when he said here that, that he was not going to respond to whether government act on their advice or not, I hold the opinion every iota of the advice of the advisory committee has been taken care of by the government. So it's a clear failure of the strategy adopted on the basis of the advice of the committee. And the government at this point need to disband that committee because it consists of, with the greatest respect, very distinguished scholars, but they are not courtroom practitioners. There is a difference between the knowledge of law in classroom and the knowledge of practice and procedure in court. The burden of proof can never shift from the prosecution to the judge. The prosecution, no matter how passionate the judge is in a criminal trial, the prosecution has the burden of proof. The saddest thing, Maokpe, is that in the most recent past, the prosecution cannot even scale beyond no case submission. We're not even talking about conviction. Establishing a prima facie allegation for which the accused will be required to defend himself. We are not even going past that level.
PACAC is not the one executing these things.
But
the certain arm of government, the executive arm of government, has been the one involved in it. The Attorney General knows that he will eventually have to take these cases to court.
Right.
And if he believes that that is not the way to go, doesn't he have a say?
Number one, the cases prosecuted by EFCC are not cases briefed by the Attorney General. The Economic and Financial Crimes Commission get their lawyer. The strategy adopted by EFCC and all the intel community are on the basis of the advice of PACAC. And my defense is that every act of government is defended first by the advisory committee chair.
You know that for a fact?
No, but it's obvious. It's in the media. Anytime, for example, if the government executes an action, the first person to defend it is PACAC chair. And in most cases, and that is the annoying thing lately, I believe in this anti-corruption fight, you know it. I have been speaking on it for the past 2 years. But these days, I have become so weak that I feel the steam is going down every day. The strategy is not working. The Anti-Corruption Advisory Committee chair have on recent time resorted to casting aspersion on the judges and have not taken closer look at the strategy that the prosecution is adopting. Poorly investigated cases, poorly prosecuted cases. Look at the reasonings of the court, whether it is a ruling or a judgment, that the testimonies of the prosecution witness fail the test, basic test. In most cases, they are speculative. And you are saying the judge will come down from the seat and begin to prosecute the case because you are pursuing an anti-corruption fight? The onus lies on the prosecution to prove the existence of every element constituting the offense for which the accused person is charged. If you fail to do that, the whole wall can fall down. You can never go past the level where you are.
So when you look at the last case, this one that fell apart at the Code of Conduct Tribunal,
right,
you actually see reason with the defense that there was really no case there.
You see, there are lots of things in my opinion, that are behind this Code of Conduct trial. From when the Senate president was discharged on the basis of no case submission, I told myself that the government, the federal government, should need to change 3 things. Number 1, disband the advisory committee. Number 2, replace the Attorney General And number 3, replace the EFCC chair. If you give me time, I will prove all of it. But on the other hand, when you look at the day the ruling was given, the attitude, conduct, and ceremony surrounding the participation in court can be suggestive in the mind of every normal and ordinary citizen, as if the Senate president had the knowledge of the outcome of the ruling. He went with mammoth crowd. The media were summoned. Even from his hometown, people were gathered to celebrate.
No, but that has always happened. I mean, we recall the case of Chief Bode George, even though he's been acquitted now. The Supreme Court says he was, found guilty in error because when he went to court, that was not yet an offense. Or when when the said offense was committed, it was not yet an offense known to law. But then we all saw a situation where a mammoth crowd of people went with him to court. They had been cooking and celebrating, and, he was pronounced guilty.
Okay, look at it. It's just simple. In the early stages of this criminal trial, you had quite a number of senators going, quite a number of media people. Midway in the trial, nobody cared. And then towards the ending, especially the ruling, there was a mammoth crowd. I am not suggestive, but I am saying that there are some things happen that leave questions, and we wait for policymakers to give us answers.
I remember I spoke with a lawyer, last week, Friday, and he was saying that could also be because the prosecution knew that there was really no case to it, and they had not been able to prove a prima facie case.
That is the part that, at the angle I have been emphasizing this morning, that the prosecution in Nigeria, there can't be a better time to sit down and review prosecution in the country like now. I'll give you an example of what you just had in your interview with the learned professor, or with the professor. You asked the question, this investigation of the SGF and the NIA has lingered. Up till now, there is no finding. And this is a typical case of something that you can come up with a result within a short time. Then the actual prosecution of high crime, advanced crime, that you need time. They don't even wait for it. You go to court before you investigate. That is the problem. Now, in the case of Saraki, kudos to the defense lawyers. They are very successful. Nobody should cast aspersion on them. And the chair of the Code of Conduct Tribunal, I remember when he was refusing every application by Saraki, everybody was praising him, including the advisory committee. And now when no case submission was upheld, they now are criticizing him. This Morino tactics of prosecution can never take us anywhere. The prosecution will need to review, because we have 3 courts in the land. If you fail at the trial court, there is a court of appeal to seek redress. If you fail at the court of appeal, there is a Supreme Court. You just cited the example of Bode George. Has it not gotten redress now at the Supreme Court? The end of the matter now can give a better explanation of the case. You are at the trial level and you are killing everybody. Judges to be blamed, lawyers to be blamed, everybody to be blamed. But the prosecution is not to be blamed. The witnesses who give speculative evidence are not to be blamed. The advisory committee who advised the government wrongly are not to be blamed. This is the time to disband the advisory committee and bring up legal practitioners, senior advocates, people who have courtroom experience of practice and procedure to advise the government on how. The other thing you had in your conversation with him, you said that judiciary and legislature are not playing a part with you in this fight against corruption. Maokwe, how can I attack you and expect cooperation from you? You are prosecuting the head of the legislature. You are prosecuting the heads of the judiciary, and you're asking them to take a part. I am not suggesting that if crime is in fact, they cannot be prosecuted. But tactics and strategy may have suggested that the first thing to do is look at other governors. Who does not know in this country that 70 to 80% of the governors who have ruled in the past may not have declared their asset correctly? Saraki could not have been the only person. And some of them are in the Senate. The strategy would have been, leave the head, focus on the body. You get the cooperation from him. You reach a certain level and you can beam the light back to him. The same thing with judiciary. But from this get-go, they went after these heads. And Saraki's case, you see, there are 2 sides to it, to be honest with you. And you cannot close your eyes from the 2 perspectives of Saraki. Number 1, the politicization of the corruption. From when this action was commenced against him, it was as a result of his emergence as Senate President. If you mix these 2, you cannot achieve something. And then number 2, they believe that somebody is funding and fueling the EFCC to prosecute him because of a political agenda. These are speculation. You cannot take it out in consideration. Then on the other hand, the Senate, the National Assembly, and especially the Senate, their lukewarmness, their inability to cooperate with the government, not